Like InvestNet and Smart and Safe, Second Chances as well is facing a 100-word summary lawsuit. In this case, we prevailed in the Superior Court, but the plaintiffs, specifically Lawal in your neck of the woods, appealed. I'm not her biggest fan, so I should just tell everyone that up front. I'm not her biggest fan. So Lawal and et al. Appealed at the Supreme Court, and we had actually arguments today on the 100-word summary. Right before this, I had a phone call with the campaign to ask what update I could provide all of you, and they said, you know, we're still churning, we're still alive, and we're still feeling good, especially after the InvestNet decision. Now, we have 2 other lawsuits in addition to the 100-word summary that Second Chances, oh, thank you, Deborah, yes. We have 2 other lawsuits in addition to Second Chances 100-word summary related to the signature curing. We turned in over a sufficient number of signatures to qualify, but the county counts, all but Pima County came back with good numbers. Pima County, though, for whatever reason, took a very conservative approach to our signatures, and now we're having to sue all of the counties to rehab 1,000 signatures to make sure we make it over the threshold. And the campaign feels pretty confident that we'll get there, but it's a very grueling process of essentially going through all of the signatures that were thrown out and finding a way to contact those people to rehab their signatures. So we're going through that. I've been told that the judge in our case has actually awarded us with more time to go through that process. We, at the beginning of this week, thought that perhaps we were going to be subject to this arbitrary deadline of Thursday, because that's the printing deadline for the publicity pamphlet. But the judge agreed with us in our arguments today that really the harm is in the other direction. If there's a ballot summary of Second Chances in your publicity pamphlet, and it doesn't appear on the ballot, then no harm, no foul, right? You're not voting on it anyway. But if it's the opposite, if we don't put it in the publicity pamphlet and it does make the ballot, then that's a problem. So it is possible that we fall under the signature threshold because we run out of time to rehab. It is possible that we lose on the 100-word summary, but because we prevailed in the Superior Court case and we're on appeal, I do feel more confident about that one. But we're looking at maybe a week before we know whether Second Chances is actually going to make it. So everyone, please send out good vibes. So Second Chances is, excuse me, sorry. Give me a second. I lost my place in my notes. Sorry, just one second. I have all 3 open, and I just don't want to tell you the wrong thing. Okay, it would establish a new accrual rate for earned release credits for eligible prisoners who are serving sentences in state prisons. It's 1 day for every day served for prisoners sentenced to non-dangerous offenses. And the analysis by Legislative Counsel is also going to say that it's 1 day for every 6 days served for all other offenses. That's current law. So some of you may be familiar with the 1990s push to expand truth in sentencing across the nation. And that was a financial incentive from Congress for states to pass laws that require individuals sentenced to serve out at least 85% of their sentence and not earn anything more than 15% off the end of their sentence, no matter what their behavior or conduct is in prison. When you think about that in the context of stacked sentences served sequentially, that feeds in a little bit to our mass incarceration problem, in that states that have not rolled back the 85% rule, Arizona and Florida being the only ones that have not, that's why we have such a mass incarceration problem, because so many people stay for so much longer for crimes where in other states they would stay maybe 50% of the And so this brings Arizona a little bit closer. I'm not going to say it's all the way, because we did not cover dangerous offenses, which in Arizona could include a juvenile sticking their finger up in their pocket and holding up a Circle K because they're starving. That's a dangerous offense. And so I don't want anybody to think that this is going to fix the problem that we have in sentencing in Arizona, but it takes us so much further than we've otherwise been, and is going to help a lot of folks who have been mostly sentenced for drug possession, really, but anything that the court considers non-dangerous. It requires the Department of Corrections to recalculate the earned release credits under the new accrual rate. I will just tell you what happens now. Our Department of Corrections can, it's almost like a kangaroo court if you have too many socks, or if there's contraband, like a cup that you shouldn't have in your cell. They can add time onto the end of your sentence and also take away any earned time that you've earned. So we are ending that. We're saying if you're going to add something on to more time onto somebody's sentence, they deserve due process, and it must be through the traditional court setting. You can't just decide. Usually it's a bunch of correction officers that just get together and decide what the punishment should be. And you can imagine the politics of that in our jails and prisons. We are also fixing the problem where we require a prisoner achieve a functional literacy at an 8th grade level before they are allowed to begin a term of their community supervision. This is especially punitive to native language speakers and folks who are not from America, who have come here, who have either immigrated here or here on, as part of like a mixed status family, or they themselves are undocumented. And what we have found is this is extremely punitive to anybody who English is not their first language, or really to anybody with a perhaps like an educational deficiency. So requiring functional literacy at an 8th grade level should not prevent you from leaving an incarcerated setting. We think that's absurd. And then it also has the impact of fixing a problem that we call the Hannah Pryor's problem. And this is actually an issue with marijuana as well, and I'll explain why. So in Arizona, it's the only state in the nation, and you can thank our county prosecutors for this, where you, upon your first appearance in court, can be charged with prior felonies if you committed multiple felonies in a series. So say I smash a car window, I smash another car window, I smash another car window. Our county attorneys have taken it upon themselves to create a norm where, say I've committed no crimes in my past, when I go to court, they're going to charge those first 2 windows as priors and enhance my 3rd sentence. And now I'm spending maybe 10 times longer behind bars than I would have as a first-time offender with 3 separate charges. And so we're going in, we actually passed a bill to fix this, and it was vetoed by the governor because Lawal and Montgomery and Polk and a few other county attorneys came forward and said that it would be a threat to public safety. So we put it in the initiative to say that non-historical priors are not priors. You have to charge someone with a felony before you can enhance their sentence and extend the amount of time they're going to spend in prison. This too has resulted in unnecessarily punitive plea deals, where they can use the Hannah Priors. You're going to spend 75 years in prison for these 3 burglaries, or if you plead down, you'll spend 10 years, which is still twice as long as you otherwise might have spent if charged as a first-time offender. And it also, most importantly, and this comes into play because Hannah Priors are most often used for small-level drug possession, even on marijuana. On marijuana, those first two possession charges, the voters passed a proposition to say that you're supposed to be diverted into rehab. But if they wait to charge you on the 3rd, you're no longer eligible for diversion. And so not only have we gone around again diversion, we're putting more people in prison for longer with felony sentences that could have been mitigated and diverted. And so those are the very basic parts of the second chances. I'd be happy to entertain questions about that very briefly if we want to move to the third.
Any legal challenges or decisions on second chances?
We are awaiting the decision of the county recorder signatures. We lost, so we sued both the Secretary of State and the county recorder on the number of signatures invalidated. We lost the Secretary of State's case in the lower court and we're appealing that. And we're currently litigating, there were arguments today on the county recorder piece where based on our progress in rehabbing signatures that were inappropriately thrown out, we need 1,000. We're feeling very confident that we'll get across the finish line. But then even if we do, we could be appealed by Lawal and others, and we are still fighting the third case on the 100-word summary today. So there's 3 cases going on.
But the Leg Council amendments were tossed out, right? The ones that defined the terrible crimes.
For the most part, yes. Yes. We came out pretty well on that. So I'm waiting. Leg Council had a meeting today to adopt the court-ordered changes. I'm waiting to say that we won until I actually see them in the publicity pamphlet. So anyway, okay. Thank you for that question.
We have another question again about if this helps the people who are serving time now.
Yes. People who are currently serving time now can begin, if passed, can begin to earn time at the end of their sentence 1 day for every 6th day. It also requires a recalculation for time served. So yes, this will actually have an immediate impact on folks who are currently incarcerated and anybody in the future. That was a big importance to us. And that was one where we could just require DOC to make those calculations based on the individual.
Hi, my name is Danielle, and my question is, if the person is serving a flat time sentence for a non-dangerous, non-violent drug offense, drug sales charge, would they not qualify then for second chance as well?
Flat time is excluded.
Now, I saw something that said they could be resentenced. Could they petition, if they're serving a flat time, could they petition to be resentenced to an 85% and then qualify for second chances?
I am not an attorney, but it's my understanding that yes, under this, you could petition to resentence. I think the discretion there is within the court on whether to take that case up. But I think especially if you fall under the Hannah Pryor's issue, I think you probably have a pretty good shot at getting a resentencing. But that is me as a non-attorney telling you that. If you want to email me, I can connect you to folks who can answer very specific questions if you're thinking about a specific case.
That would be great if you could put your email in the chat. Awesome, thank you.